Well, you don't know what you're missing out on. You know.
Are you going to share the screen then later, Joe?
Sorry?
You're going to let me share my screen?
What, have you put enough 50p's in the meter?
I have, yeah.
Hang on, why are you sharing a screen? You're not the guest, you're the interviewer.
No, I've got a bit of a PowerPoint from Reema. I thought I'd just.
Oh.
I don't necessarily. I'm not concerned if whether we use it or not. I just know that when I was talking to Surinder, he sort of mentioned to have one, so I just did one for the sake of it.
Yeah, just from our sort of 18 months experience, it's great to have a PowerPoint because everybody watching on Facebook suddenly goes to sleep. So have a PowerPoint. And Bob,
but this PowerPoint is strictly about introduction. I haven't done it on the topics that we're covering today, so I'm not concerned whether we have it or not. I can do an introduction just sort of without referring to the PowerPoint.
Don't worry, share your PowerPoint. I'll put the 50p's in the meter on your behalf as your first time here. So, right, let's do a quick introduction. Surinder, we're ready to go. We are live on Facebook, I believe, he says. Right, so, hang on, let me put it on speaker. Otherwise, Nish should tell me off. Great. So everybody, good afternoon. It's Thursday afternoon, just after 5, and we're all recovering from the fantastic England match yesterday, even the non-England sport, even the non-football supporters. Sorry, Danes, tough luck, not your time this time. Right, so TPB, we're here to talk about football. No, we're here to talk about property matters, right? And as you can guess from last night's celebrations, we've had a few of our usual panelists have decided to call in sick. Now, Simon, my usual co-host, amazingly concocted up the excuse that he was on a golfing something. I don't know what he does. Anyway, we will ignore him. I won't say anything bad about him.
Shocking.
Bob, the superhero, stepped in his place. He's co-hosting with me today. And we've got a super fantastic guest for you today. If there's one person you need to have in your property team, it's this lady, and I'm going to hand over to Bob to introduce her in a minute. But I've actually lost my book somewhere. So put away your coloring pencils, get out your pens and pencils, take notes, because this is one person you want on your power team if you're a property professional. I'm not going to let the secret out. All I'm going to say is this is so special that I'm even going to put all the 50p's in the meter for her to share a little slides. So Bob's become my regular member of the team. He won't be spilling guts out on the estate agency this week, but he'll be doing something better. Bob, over to you, mate.
Good evening, everyone. How are you all? Thanks for joining us on the Property Professional Show. And thanks, Joel, for that brief introduction. Yeah, I think everyone's away today, aren't they? The Maharaja, Bobby Madden, and Simon, having a good time, no doubt. So here we are, just the three Turbinators here now. So we'll count on.
I'm telling you, it's that football celebrations. It's not agreeing with those guys. You know? Anyway, look, we have to let them off.
I think Bobby was at Trafalgar Square or Piccadilly Circus at 1 o'clock last night when the police came.
He'll tell you he was looking at a property deal.
He definitely
don't believe whatever that guy says about Leicester Square.
Whether he admits it or not is a different matter, but I'm sure he was there.
I'm sure you're right. And Bob, look, thank you for and so, look, at least Simon had some foreplanning. He planned it a week ago. He obviously probably knew he had some inside information on the football.
I know.
So anyway. I'm going to stop talking nonsense, but I'll put the 50 meters on.
But yeah, today we're really, really excited to have a wonderful lady with us, Reema Chugh. She is a property litigator and mediator. Now, what that means, I have no idea, but we'll talk to her in a minute. Basically, she's been involved in insolvency, banking law, you name it, anything to do with property, residential or commercial. She's the go-to person, and she's very, very active on social media. She's here. She's made a special time to join us, and we're honored to have her on the show. So, welcome, Reema.
Thank you very much. May I add, I've actually made the effort to join today on my annual leave. So,
yeah.
Oh, not only have you made it on your annual leave, you've made it after an England victory after
absolutely
55 years. Look.
Yes, there we go. So, you know, I'm all up for the football match. I was watching it yesterday, of course.
Yeah,
Was I?
We're going to have to get you a special slide next time.
Yeah.
Well, back to you, mate.
That's okay. That's okay. If I could share a slide, please. Can anybody see this?
Yeah, yeah.
Yep.
Fantastic. Obviously, the tablets are working, Bob.
Yeah, it's working. Yeah, I've paid the bill.
Yeah.
So this is Reema, your trusted litigation solicitor and mediator. Now, this is a bit of a background on what sort of areas she covers: litigation, construction. Obviously, there's a lot of litigation happening on that front at the moment. Debt recovery, somebody owes you money, she can pursue them for you. Insolvency, which is bankruptcies, IVAs, insolvencies, and receiverships, that sort of thing. And then she's also an expert on breach of contracts. A bit of background on Reema. She's worked at the top firms in the country, top 100, no doubt, no less. And she's also headed up a property litigation department, so she knows her onions. And she's also got international experience under her belt, having worked for clients from Dubai, Australia, and further afield. And she's obviously worked very, very closely with lots of barristers. So we're really, really happy to have Reema here. And let's move on to some questions, if that's okay. If I just cut this out. Right, Reema, thank you for joining us. Yeah, what is mediation, and what sort of litigation work do you get involved with?
So mediation is really sort of for anybody who finds themselves in a bit of a conflict, whether it's a dispute relating to property matters, construction, or any type of other legal matter. Instead of actually going to court or going to lawyers, you can actually instruct a mediator to help you resolve that conflict. Now, one of the things that I started up, which might be relevant for this group, and I must mention it, was Asian mediation services, because I find that people in our communities are not aware of mediation being a very useful tool that's available out there to help resolve legal battles. Now, people think if there is a conflict, let's go to lawyers, let's see you in court. And it becomes very quickly a matter of principle that you must have your day in court. But actually, all you're doing is taking your chances a lot of the times, because litigation always comes with risks. So you can have the bestest of cases. We've seen bestest of cases go to court, good evidence, everything, good barristers on board, really good team of lawyers. But on the day, the judge may form a different opinion because of how your witness gives evidence in court. So it could all very much turn at the very last minute. So you are taking a great deal of risks, even when you're advised that you've got a good case, and your lawyers will always tell you that. So now, to avoid all of that risk of time and money, you can actually engage with a mediator who will help, who's an unbiased, trained professional. They'll help you resolve your conflict. Usually, it used to be done pre-COVID times. It used to be done at a venue where you'd have the mediator see both parties in one room together, explain the process. Then they get split into different rooms, and the mediator will help you facilitate a settlement. Okay, a lot of the times this settlement would be what the parties are looking for, things that you can't often achieve in court, because what happens is when you go to court, you've always just got one person who wins, and even when you win, you only recover 60 to 70% of your legal fees. So you've always made about, even if you're successful, about 30% or so of your cost that you've just wasted, or potentially you're not going to recover. Now, in mediation, it really is a case that both parties walk away with a resolution that works for them and is quicker, and you don't have to wait for as long as you may have to for court trial. So, I mean, we all know because of COVID, there is courts are very, very behind. There has been so many grace periods that have been allowed, whether it's for property matters or whether it's for debt matters. And it's all coming back in the pipeline again with restrictions being lifted. So there is a huge backlog. So you could be waiting years before you get your day in court.
Absolutely.
So mediation is very helpful, yes.
Yeah. Now, does a mediator have to be legally qualified?
A mediator doesn't have to be legally qualified. They get their own separate training, but of course it's very helpful if your mediator is legally qualified, or is a solicitor, or is a barrister, because most of the times when it comes to these legal sort of disputes, either the mediators were solicitors, practicing solicitors, or barristers, so they've gained experience and knowledge in the area, so they're well averse to engage in that mediation, or they're currently practicing. So it's always helpful, and it's an advantage that you can have. So going back to the point very briefly about what I mentioned about Asian mediation services. So I did start a Facebook group where I was encouraging our Asian communities to engage in mediation and try and help. We have a team of mediators who speak Hindi, Punjabi, and Urdu. So it was a case of actually helping our communities engage in mediation and overcome that language barrier. Which can often
great idea.
Yeah.
And has it been well received?
Well, to be honest, it's actually been received quite well. Yeah, so we have had quite a few people engage our services, and there is another sort of, I must mention, there is another sort of organization that does a similar type of panel of mediators that they have that speak Punjabi and Hindi and Urdu. So, you know, there is their organization, which has been running for quite some time, and something that an initiative I started at very low cost. So yes, people are using it, but I think it's just a case of managing a full working life and mediation. It can take its toll. So yeah.
It's not easy, is it? Okay.
Yeah.
Obviously, yeah. I mean, obviously, we're now coming out the pandemic, and like many landlords, tenants, you know, sort of fell behind on their payments, etc., etc. Now, I'm sure some tenants are sort of, you know, just taking the Michael. But if a landlord really wants to evict their tenant, residential tenant, what's the procedure?
Okay, so now the procedure for evicting residential tenants, there is back in when coronavirus, sort of when we hit the pandemic and the restrictions sort of happened, there was something that the government introduced, which was a relevant period. So the government said that you couldn't actually evict your tenants if for rental arrears. For example, if they were during the relevant period. So the relevant period has been extended every 3 months since last year, March 2020. Now we're still within that sort of relevant period. However, the restrictions have eased quite a bit. Now, what the rules say is that if there are at least 4 months arrears, you can give 4 weeks notice to your tenant. And then after that 4 weeks, what you can do is you can issue possession proceedings, because what you've got is with residential properties, you can't just go and change the locks. You've actually got to have a possession order. And even after the possession order, if the tenant doesn't leave, then you've got to actually get a bailiff or a high court enforcement officer to go and change the locks or evict the tenant. So you physically can't, landlords can't do anything. So the starting point is serving the notice. So 4 months at least you need arrears or 4-week notice. And of course, if it's less than 4 months arrears, then you've got to serve 4 months notice. And that period is from the 1st of August 2021 up until, I believe it goes on to September. So those are the current notice periods, but notice periods were different prior to the review most recently that we had in end of May, beginning of June. So yeah, those are the current notice periods.
Okay. So what notice do you serve then if it's an arrears situation?
So it will be a Section 8 notice that you would be looking to serve if it's a rental arrears situation. But of course, you know, there are various other breaches of tenancies which you know, we need a complete separate 2-hour webinar to go into that, such as sort of illegal use of property, and you know, you've got the Section 21 as well, and then rights to rent. If somebody doesn't have that, then it's shorter periods. But if we're strictly speaking about rental arrears, you've got to use a Section 8 notice.
Now, there was some talk of Section 21 being sort of disbanded. What's that about?
So you've got the new forms at the moment. So currently, as it stands, you can still serve a Section 21, but there is new prescribed forms. As and when things change and take effect, that's when, of course, as a legal sort of representative, I can speak about it. At the moment, consultations take place and there is discussions. As far as we stand today, the Section 21 notices can be served.
And where is it that landlords go wrong? Why do their cases fail when it goes to court?
To be honest, a lot of the times we see incorrect notices being used, incorrect time frames, so people not allowing enough time for service. So you serve the notice and you've just not given enough time. Or it is a case with Section 8, there isn't the exact amount of arrears that you need to be able to benefit from the shorter notice period currently, for example. So those are the kind of things. I mean, service is an issue, the correct notice form being used, the correct details of the party. It's very basic things that we're talking about here, but people can quite often trip up on those things. So it's very important to make sure these notices are on the right format. That's a starting point, and it mentions the right parties, and you allow enough time for the other person, the tenant, to receive the notice, and mention in your notice the date for when possession proceedings will begin, as allow extra few days after the notice expires. So that's always sort of beneficial tips to bear in mind.
What if there's no tenancy agreement? How can you evict somebody if you've not signed up a tenancy agreement?
So it really does very much depend on the circumstances. So if there is no tenancy agreement, but you've been accepting rent, there will be some form of implied tenancy here. Whether or not you would argue whether that benefit is an AST or not, it will very much depend on the facts of the situation and the case, and how that tenant actually came about residing and occupying the premises. So if you're accepting rent, you've given sort of after the person has come into occupation, but there is no tenancy agreement, but you've actually served EPC, gas safety, and you've complied with all of that, then you can imply that there is a landlord and tenant relationship here, which is protected under the AST if it's gone on for a certain number of time. But each case depends on its own facts. Naturally, tenants will always argue it's an AST, but to argue against it, you've really got to prove that it wasn't intended to be a protected tenancy.
Yeah. What if during the pandemic you couldn't get into the building to do an up-to-date gas certificate or electrical certificate, and now you want to evict? You haven't got your paperwork or your deposits being renewed. Are they big issues that the courts will throw the case out, or do they still allow evictions to happen?
So essentially the rules are as they are, and if you can't get access to the property, then your option is to actually go to court and issue proceedings to get an injunction that you have an order to go into the property. So you would be looking at your tenancy agreement, if there is one, which would normally, most ASTs will mention that you can go into the property, you giving reasonable notice and so on and forth, then it must not be denied. If the tenant still continues to not cooperate, then of course your option would be you can't just go into the property. You've got to try and get an injunction to get an order potentially. Yeah.
I mean, during the pandemic, everyone's had benefits like bounce back loans and everything else. Landlords haven't. So, I heard there was another scheme announced where you've really got to give the tenant more time than you've already done. Something called the breathing space or something like that. What was that about?
Yeah, so of course there is the breathing space, which the government it was spoken about, but it was spoken about last year, but it didn't come into effect until sort of this year. And there's two types of breathing spaces. One is to, of course, relating to any debt that somebody owes you. You can have up to 60 days in which no enforcement action can be taken against that debt, okay? And then of course the other one is in relation to if you've suffered mental health crisis as a result of the debt and the pandemic and so on and forth. So you can get that breathing space, so you've got to just leave them alone. As soon as you become as a landlord aware of the fact that the tenant has applied for what's called the breathing space and they've been given that breathing space, you just got to leave them be for that 60-day period and not take further enforcement action. Now, it's coincidental. It happened on one of my cases today where we received notification about the tenant having that breathing space they applied for that's been granted. Now, it was a Section 21. The High Court enforcement officers are booked to go in next week. So she's applied for it, but it doesn't affect us because it was a Section 21. So it's not relating to the arrears, it's just relating to getting possession of the property. So you've got to see, if it's strictly relating to the debt, of course you can't take any enforcement action. Possession of the property, that's what you're enforcing, then you may be able to go ahead.
Go ahead with it, okay. It just means the landlord gets further arrears, I guess, and
that's it.
Has to suffer, basically. Okay, so that's residential. Yes, Jill, were you going to say something?
Yeah, Reema mentioned mental stress and rental arrears. Do they take account the mental stress of the landlord and rental arrears for those guys as well?
So the breathing space, of course, I mean, the breathing space is intended for debtors, really. So it's you know, it's really a case of people, people who owe money, rather. So it's, unfortunately, I take this is a discussion I've been on other panels where landlords do feel that they've been left behind quite a bit, and rental arrears have been accrued. But look, it's important to bear in mind that there are other provisions. I mean, residential properties as a starting point is very difficult, because if your tenant is unable to pay, that means they're renting. Firstly, do they have any assets? Because there's nothing stopping you from actually pursuing them in the county court to get a judgment against them. So what that does is you might not be able to get possession of your property because there was a ban on evictions and so on up until earlier this year, end of May. But what you can do is you can issue proceedings by which you'll get a judgment. And if you know your tenant has got any assets, then you can appoint High Court enforcement officers, for example, to recover the amount of that debt that is owed. Or you can pursue the guarantor under the tenancy agreement. So a good tip is always, for residential landlords, is try and get a guarantor in place, because breach of the warranty, breach of obligations in a tenancy agreement, which is effectively a contract by the principal party, i.e. the tenant, the guarantor is guaranteeing those. So you can go and enforce against the guarantor.
That's a very good tip, isn't it? That's a very good idea.
I mean, my comment was driven by, everybody assumes if you're a landlord, you've got loads of cash, but it's not always the case, because a lot of the times these accidental landlords or landlords, they don't have infinite resources. They're probably using the rental they get to pay the mortgage.
Absolutely. And absolutely, I mean, there's so many people around who, I mean, for example, I was mentioning another client of mine who's in another country outside of the UK, has not been able to sell his property, his retirement home, because the government restrictions. The sale fell through, and that's a retirement home he was relying on to retire and use the funds to sort of get on with his life. But it's 12 months more on, and he's not been able to recover possession of his property and sell it.
Yeah, I think a good tip for landlords would be, to make sure, firstly, get a guarantee if you can.
Yes.
I suppose you could insist on your tenant taking out some sort of income protection if they're laid off work or something like that, or if they're sick.
You couldn't insist on it, but you could advise it. So obviously the thing is to build an active sort of relationship with your tenants, to communicate, because a lot of the times I think where government launched the mediation service to help landlords and tenants come out of their sort of disputes, and what possibly that mediation service will do is encourage people to communicate, because a lot of times people just don't communicate and don't sort of, the impasse the gap becomes bigger and bigger. So I think the key is to try and sort of make sure you can advise them, look, these are the insurance premiums that are available. Or landlords also have, I believe there are products available in the market to cover for any rental arrear periods, providing you've done everything compliance wise and done your checks.
Yeah, I think some people neglect them to their peril. And from my experience, I've seen tenants insure their sofas and carpets, but not their income or their health. So I think it's a case of educating tenants to make sure, look after your income, look after your protection, and because if you don't pay, you will be made homeless. So I think it's incumbent on both parties, as you say, to communicate and put forward any suggestions. But interesting. But yeah, that's the residential scene.
Sorry, just a quick interruption. Did I understand that right? That you said the tenants can take out a rental protection policy as well as the landlords?
No, income protection. So if they're sick.
Okay. So,
I mean, at the moment, it's very hard to get a redundancy policy.
Yeah.
But they will come back, because a lot of these was because they're either laid off work or were ill. And under an income protection policy, those are things that you might be able to claim against. And therefore, the income keeps on coming in, and then you can keep on paying your rent.
So the tenants take out an income policy, and landlords will take out a rent guarantee.
Yeah, each can look after their own. So if one doesn't work, the other might. So, and that would sort of reduce or minimize these sort of incidences, I guess.
I mean, it's practical tips, isn't it? I mean, people quite often, if you're an experienced landlord, I guess you wouldn't really think about this unless you know somebody who actively rents and has done or has built some experience. You wouldn't think about these things. And, you know, if people are watching this and they're thinking about going into property investment in the residential side, it's important to bear these things in mind and speak to somebody who's actually been experienced landlord, because more mistakes, it's becoming more and more onerous, the legal obligations on residential landlords, what you must do, and you know how you, if you haven't done it, what can you, for example, deposit protections, the massive one. It's if you don't protect the deposit, and you allow, say, 12 months, you know, your tenancy expires, you allow it to roll on a monthly basis, there is potentially an argument there that you've got to protect the deposit again because the term has expired and you've got to start to protect it again. So if you don't, you can be fined up to 3 times if you don't protect deposit. So it's small things, but it can cost a lot of money.
Yeah. And this brings me on to the point that, you know, people do try and let properties out themselves.
Yes.
But in doing so, they do maybe neglect some important issues that are,
yes,
you know, or could be very, very relevant in the time of repossession.
Absolutely.
Or an eviction, should I say.
Yeah.
Okay, moving on to commercial, Reema, how does that vary from residential?
So now with residential, you've got the protection from Eviction Act, so you can't just go and change the locks. Commercial, a little bit more easier in terms of what happens if your commercial tenant hasn't paid the rental arrears. Potentially, you can go and change the locks. That's called peaceable re-entry, however, not right now. So please don't, anybody listening to this, please don't go ahead and get off your chair and go change the locks right now, because there is a current ban at the moment until 25th of March 2022. So although you can continue with residential evictions, the government has extended the ban on commercial evictions. So
even worse.
I did see you, Dil. So yes, you can't, essentially, what's the option then? Where does that leave a commercial landlord? Now, of course, you can't peaceable re-enter, you can't evict them from the premises by even issuing court proceedings, because of course, peaceable re-entry, which is changing the locks, it's sometimes in the lease. If it's not in your lease, then it's always best to go down the safer route, which is issue court proceedings. Now, that's for rental arrears we're talking about. But of course, even if you were to issue court proceedings now, you're not going to be able to, you might get a possession order, but you might not be able to, you're unlikely to be able to get anybody evicted because of the ban. So it's not worth you pursuing that route at this stage. What can you do? You can, again, issue proceedings to recover that debt if you believe that your tenant has any form of assets against that can be used to pay off the amount of debt that is owed. You can mutually agree to surrender the lease and come to a commercial deal to say, well, look, okay, I understand there's 2 years left, but we know 1 year rent is outstanding. Let's make a commercial compromise. We'll release you of your obligations, providing you pay X amount. Or there could be charges that could be agreed to put on somebody's property. For example, if the commercial lease is in the name of a director, personally, not the company, you could agree that the director firstly gives a personal guarantee. If not, then you could potentially agree a charge to go on a company asset or the director's asset if they're willing to. Those kind of deals you can make. Of course, if you've got a tenant who's just suffered as a result of the lockdown restrictions, but they are actively going to be able to sort of pay the rent and they had good history. So court proceedings, commercial sort of considerations or deals that you can enter into. So those are some of the options. I mean, the most straightforward ones, of course, there is the CRAR, which is the commercial recoveries that you can go down, but you've got to have excess amount of arrears for that. So I'm not going to go into that. And if anybody wants further information, then, you know, feel free to contact me because it's forever, it's constantly changing the number of arrears that you want. So those are the options. I mean, previously I would have suggested that you could also serve a statute demand, but again, during the relevant period, the restrictions are shortly to expire for service of statute demand. It threatens bankruptcy, but you can't do that at the moment either, I believe.
Okay.
For just strictly for non-payment of rent. But of course, if there are other breaches of the lease for the commercial premises, then that's potentially a route that you can go down to obtain a possession order from the court. But all other breaches are, it's quite difficult anyway to get possession on those, because the courts tend to say, can you remedy them? If you can, then remedy them. They're not, then they're unlikely to give you a possession order on those. Mostly rent arrears are mandatory there.
What does it all cost? I mean, the landlord, or the poor landlord, should I say, has not had his rent for 6 months. He's now faced with having to go to court or mediation. What's it going to cost him? And, you know, how does that sort of change their mind one way or the other?
So how long is a piece of string? To be honest, look, it very much depends on 6 months arrears. If you're not able to come to a resolution and it's the parties have reached an impasse, costs, it's difficult to put a figure. It can be tens of thousands, it could be a couple of thousands, depending on sort of the action that you took. For example, a letter before action could be served by your solicitor if you decided to take legal advice to say, look, these are the rental arrears. We are looking to issue county court proceedings against you. You'd have a judgment, and that's unlikely to reflect very good on the company or whoever it is that's a party in the lease. Again, the other option is to go after the guarantor, or use a rent deposit deed and look at that to say whether you could use some of the money in there to recover your arrears that may be. So 6 months arrears, substantial arrears, of course, look at the rent deposit deed, look at whether or not you can issue county court proceedings, because if the tenant has any assets, look at whether there's guarantor that you can enforce against. So those are the things, I mean, you know, initially that you'd want to start before. If the tenant doesn't have any money, you're basically knocking your head against a brick wall, really, and you're wasting a lot of money and legal costs, and it's stressful for both sides, not just tenants.
But supposing the tenant does have assets in the background, can you add all these legal costs onto the bill?
Well, most leases will allow enforcement cost, or any sort of legal action that the landlord has to take to enforce the terms of the lease as legal costs that you can add. So yes, you may be able to add those costs. Generally, once proceedings are issued, you become entitled, just by civil procedure rules anyway, if you're successful, you become entitled to 60 to 70% of your costs. But of course, if your lease has a clause in there, which most leases will do, you can add that on there, yes.
Okay, and you can go after the director's personal assets if he's guaranteed the lease himself.
If there is a personal guarantee given, you can enforce the guarantee, but of course you've got to follow the right steps to make sure the debt is crystallized before you can go after the guarantor. So that means you've got to make sure you follow the right procedure in the lease to demand the debt from the company. If that doesn't happen, follow the right notice periods and issue it to the directors, demand it from the director, and then see what the personal guarantee says about how you can enforce against the director.
If a tenant, for example, leaves voluntarily, hands back the keys, the shop's full of equipment and stock and things like that, is the landlord able to just sell it off to the best bidder, or does he have any obligations to give the stuff back to the tenant?
Of course, if the tenant leaves the property in there that doesn't belong to you, you've got to either try and come to a mutual agreement by which you say, look, you owe us this much rental arrears and we'd like to use that. There may be some provision in the lease for that. Good drafted leases that we've seen will talk about any assets, so on and forth, but there is at the moment restriction on how many days in arrears you have to be able to recover against somebody's tenant's assets, for example. So you can't just sell it off. The short answer of that is you do have certain obligations and procedure to follow before you can use those assets as your own to pay off any debt that might be owed.
Yeah, poor landlords, they get it from all sides, don't they? They have to follow so many rules and regulations to get their money back even. So yeah, not to be entered into lightly, I guess.
Yes, I mean, to be honest, like I say, there are options out there, as we mentioned. If court proceedings should be the last port of call, because if you've got a good rent deposit, you've got personal guarantees, you've got you've got commercial sort of arrangements that you may be able to reach with them, and then if all fails, then yes, issue court proceedings. If tenants got assets, then yes, you should be able to recover that.
So it's always good, I suppose it's advisable to make sure you've got good lease from the outset. So is that something that you do?
I don't get involved in the transactional stuff, to be honest. So I'm only when things go wrong. It's good times for me. So, but there are transactional property lawyers, friends and colleagues. If anybody has questions, I can point them in the right direction. Yes.
Yeah, I think from what you're saying, a well-drafted lease is probably worth its weight in gold.
Yes, yes.
Come the day when you might have to evict that tenant.
Yes, and it helps. It helps, obviously, for me to if I get contacted by a client, for example, I can't help, but of course I've seen when things go wrong, so it's helpful for me to provide my input before it goes off and it's completed. I always tend to have a look at, can we add X, Y, and Z, because I've seen if you don't have a personal guarantee, or if you don't have a good rent deposit, or if you don't have something else in the lease, then it could make it very difficult for the landlord. So yes, it does help to look at it from this side of the table as well. Yes,
absolutely. So just to finish off, what are your best 3 tips then to landlords?
Best 3 tips. So first one, as we've just mentioned, would be a good drafted lease/tenancy agreement, which would make sure that all the issues that could become dangerous for landlords are covered to the best, because no contract or lease would be bulletproof. There will always be things that you miss out, but the best starting point is to make sure that it has most basic issues for rent deposit and guarantees in place, and of course about assets that you can use, or in the event of rental arrears. Secondly is to make sure, for residential landlords, is to make sure that you speak to an estate agent, whether they're quite knowledgeable these days. Some of them, they're not legal advisors, but they're used to sort of renting out properties. They're aware what you need to do. So make sure you protect deposit, make sure you've got an EPC, gas safety, EICR, which is a requirement that came in earlier on this year as well, that you've got to have. It's been made compulsory. So make sure you've got all of those checks before the tenant moves into the property. The third tip is try and engage in mediation more, as opposed to relying on courts, because you will have a long wait before you get your final day or hearing in court. So you'll spend money, you'll spend a lot of legal, you'll spend money, to be honest, do I say waste your time? Not necessarily, because people do get justice and that's what the courts are there for. But you will invest a lot of your time. It will cause a lot of stress. Courts don't like it either when landlords and tenants don't attempt mediation or try and resolve their disputes outside of court. Courts are working on making mediation compulsory in civil cases now. So it's going to be made, I anticipate, in the coming years, that we would have more and more pressure from the courts to use mediation. So try and use mediation. Don't be afraid of it. Most mediators, if you select properly, are legally trained in their past life or currently. So it could be a very helpful tool for you.
That's very good. What about a pandemic clause? I mean, a lot of leases wouldn't have had that, because they're, we've never been in a pandemic, I guess, in the last,
we have
70 years or whatever. But is that now a good idea to try and insert one, so that both parties know what would happen if we had another wave of, of this pandemic?
It's always good to have that inserted in a clause, because we're aware what you don't know, you don't know. So we previously didn't have these clauses in many contracts. What you had were people relying at the start of it on force majeure, which was, it becomes impossible to perform a contract. But that doesn't apply necessarily to residential because people were weren't able to pay because of furlough, but perhaps so on the commercial side of things people try to argue, but it's been very difficult to prove that you impossibly can't perform the contract. So yes, it's useful to have a clause. How parties and lawyers will encourage people to have a clause like that in leases is yet to be seen. I'm not sure, I'm not a transactional lawyer, what people are sort of starting to do, but it's always useful now that we know that these situations can happen, then yes, to have a clause which may help both landlords and tenants and give some breathing space outside of the regulations.
Oh, absolutely. No, so I think it's a good idea if both parties can, you know, agree and come to terms. It's not a bad thing to do. So
the question is, I mean, what would from your perspective, Bob, it's a case of every client will have their different needs. So if you wanted something about the pandemic, what would you want in your lease or your tenancy agreement?
I mean, as a tenant, I would probably want an element of rent reduction, I guess. You know, because especially if your business has been closed or happens to be in a sector that the government do not want to open, for example, restaurants or, you know, places where people gather. If you're in that sort of sector, I would probably ask for either a rent suspension, if the landlord will take that, because if you genuinely can't open and you genuinely can't trade, then there's no way you're going to pay the rent.
Yes.
So what does the landlord want? A tenant that will bounce back after the pandemic's over, or have an empty premises? So I think it's all down to bargaining and discussion.
Yes, and I think it will depend on the nature of the business.
Yeah, absolutely. Yeah.
So absolutely, I think it's a valid consideration for people to bear in mind, whatever it is that we've learned from our individual circumstances, what would better help us, because we've, as landlords or tenants, whatever your experience has been, what would help you. So it's always worth suggesting that to your lawyer. Can we have that in the contract? Is it going to be enforceable or not later? Because that's always an argument that you can have in court, or parties can advance to say it's just not practically enforceable. It's
it could be deemed an unfair contract.
Yes.
So all those things come into it. But no, thank you very much. Dil, do you have any questions?
Yeah. So Surinder's got a question. Before I go to Surinder, just touching upon something Bob said, where the tenant leaves the goods, and this is probably commercial premises. I believe it's covered by the Ramalfa clause, i.e. the ownership does not pass until the goods have been paid for by the supplier.
That's it, yeah.
So watch out for that. You might be effectively dealing with goods that are still owned by the supplier. And I'm guessing that this might be one of your 2-hour webinars, but it's going to become really interesting in terms of where investors have bought commercial property for the purpose of development, and the rules slightly differ in that, don't they? Just don't have full question yet, but I might book you in for another session.
Yeah, that's fine. I mean, it's like I say to you, a lot of the things that we've covered today, it's been very brief, and we've only just touched the very top end and on these things on surface. For example, as I mentioned to you, the question about can you use the goods that the tenants have left, and again, as you mentioned, Dil, there is the issue of you become an involuntary bailee of those goods in situations. If it's not consented, you can use them. What are the number of days? What are the notices that you need to serve? Is it being fully paid? And who owns these goods? And all of these things, of course, we need a detailed sort of discussion on it altogether separately. But this, it's important to bear in mind, you can't just, for the purposes of today, you can't just use those goods to recover the amount of debt that you're owed.
Great. I think Surinder's got a question. Surinder,
yes, relating to the same question. Of course, the tenant has left the goods in there, whether they're his or not. The landlord can't re-let the property until something's been done. So is there effectively landlord can charge rental for that? Storage?
Yes, of course. So that's the kind of debt that would be added on. So you would be saying if you're not able to rent the property because the goods are occupying that space, then you're adding rent and that debt is being added on top of that. So it's the losses that you're suffering as a result of that. You would be adding to overall debt that you're looking to recover from the tenant.
So if it's cheaper for the landlord, can he hire a storage space and put it there rather than forego his rent?
Sorry, you broke up there, Surinder.
Is it feasible for the landlord then to hire a storage space and put the goods in store rather than lose the rent, which might be higher than the storage?
Yeah, it depends. It depends. So you've got a duty to mitigate your losses depending on the size of, so for example, if we're talking about commercial premises, I'll give you an example. One of my clients' premises had tenants leave big machinery. So can you practically store them somewhere else at a cheaper cost? And how long do you do that for? Or is it a case that do you move them? What if they're damaged in the process? Who is guaranteeing those things? But let's look at the residential side of things, which is a bit more straightforward when it comes to goods being left behind. Those are the things that you would expect landlords to put in storage, because it would be household furnishings or clothing or whatever it is that you could easily store in a storage and allow your property to be rented out again, whereas commercial, it can be a little bit more difficult and tricky.
Now, there's another tricky point there as well, that the tenant might claim he's left a lot more than what was actually left. Who is to be responsible for what?
So to overcome those kind of issues, you've got to make sure when the tenant leaves, you take pictures. There is independent person there. For example, commercial premises, you might want to take a surveyor, an independent surveyor with you, who would be able to take draw up a report. Then you'll take pictures and so on as to what was left behind on the site to be used later on. Now, if it's residential, I would always encourage to do the same, to make sure that you've taken pictures of what was left. These are timed pictures, and the tenant will have to prove as well. So mind you, the claimant in English courts, when you're making a claim against somebody to say, well, actually, I had more than what you're giving me, you've got to prove that you had those items. Okay, so of course, if you're honest in what you've done and you believe those are the things and they never existed, they're unlikely to be able to prove that.
Okay, coming back to mediation, you said something about that mediation is a better route because both the parties walk out with a say a better result than they would in court. Now, as you did say something about is it at the moment compulsory or not? If the other party doesn't want to go into mediation, can you force them?
It's not compulsory. Yeah, it's not compulsory at the moment, but what the courts are looking at is encouraging it more and more before parties issue proceedings or even during the course of it. So, for example, in small claims, you automatically, when you fill out your questionnaire, you ask, would you want to engage in a free small claim mediation service? Mm-hmm. Mostly you're encouraged to say yes. It's not compulsory at the moment, but if there is many cases, for example, bigger disputes, if one party rejects mediation proposed by the other, there can be quite heavy cost implications imposed on that party, especially if they're not successful in beating the other party in court.
Just 1 minute. You mean heavy cost penalties in what sense? The person refusing would be subject to
mediation, yes. So yeah. The courts, yes. Some judges have actually awarded heavy cost orders against the party who's rejected mediation, even when they've been successful or whether they've not been successful. So it depends on the value of your claim and depends on the day of the trial and what that particular matters, what the court's view is. Is this a case that could have been resolved at mediation, but you unduly rejected mediation that was proposed by the other party? So in those situations, you can have heavy cost implications, and the courts have actually made severe cost implications and sanctions against parties who rejected mediation proposed by the other.
So it can only happen, the mediation can only, at the moment, is after the issued proceedings.
No, you can enter into a mediation even before you issue proceedings. You can enter into mediation 2 days before you have your final trial. Of course,
but you have the trial and issue is two different methods. I'm talking about issuing proceedings. So how can mediation come into effect before you even put in your issue proceedings?
Because when there are two parties in dispute, you know there is a conflict. You're going to, when you're issuing proceedings before that, you can engage a mediator.
Okay.
You can say, I'm looking at issuing proceedings, or I'm in a dispute with the other person because of X, Y, and Z. I've proposed mediation and they've agreed. Are you able to act for us as an independent mediator? And the mediator will look at both sides' case summaries or case position statements that you would send them and confirm whether or not they can assist. If they can't assist, then they will refer you to somebody else. So before you even issue proceedings, you can engage the services of a mediator to help you as the last port of call to say, well, actually, before I incur the issue fee, let me try and resolve this by way of mediation. So you put it to the other side to say, look, we're not getting anywhere. Of course, I'm looking at issuing proceedings, but I suggest that we try and mediate this, which might be cheaper and cost effective and time effective for both of us. Here is a mediator, or here's a list of 3 mediators I suggest. Can you let me know if you're agreeable to this? And then you can both engage in a mediation.
Right.
Yeah.
Okay. Are the mediator's findings or judgment binding?
They're not binding. So the mediator doesn't make a judgment. Essentially, the mediator's job is to facilitate an agreement between two parties in a conflict. Now, once the agreement is reached, the parties, if you're legally represented, the solicitors will draft what's called a settlement agreement, which will be signed by both parties, and that's your contract. Okay. So yes, if that contract is breached because you don't do something that's in that mediation, then you can take legal action against that person for breach of contract. Okay, so that's a binding contract then.
Okay, so that's fine. That's only if the mediator's agreement is accepted by both parties, will it become a contract. If one walks away, then it's null and void.
Yeah, so of course, mediation is confidential. So up until a settlement has been reached, so the mediator doesn't make a judgment or recommendation, essentially. It's mediators helping both parties assess the position and come to a settlement which will work for both of them. So now if you, Surinder, for example, and Bob and Dil are in a dispute, I'll be speaking to all of you and I'll be saying, look, this is the position. I'll encourage you guys to come to a settlement, okay? Once you've said, right, I'm happy with this, all you guys are happy, you've made your offers, you've exchanged proposals, and you've reached a medium, then your solicitors will draft an agreement which you will all sign. So that's how it works. I'm not going to be passing any judgments. I'm just helping you come to.
Sure, I understand that. It's just that even after you've done the job and they have agreed at one stage, later on they can change their minds and not sign the agreements.
Yeah, so of course the key is most of my mediations, I'll make sure that the parties will sign the agreement, or their legal representatives will encourage them to sign the agreement. If you reach a settlement, you've obviously gone through a whole day of labor and you've thought about it and you want to enter into that settlement because you want to walk away from the dispute. So 9 out of 10 times people will actually sign it afterwards. But if you don't, yes, that's an issue. So because mediation is all confidential. So up until
But can that mediation, if it's not agreed by one party who walks away after agreeing, can that be presented in front of a judge if proceedings were brought forward after?
It's a very technical point here, because on one hand you've got mediation which is meant to be entirely without prejudice and you can't discuss anything unless the settlement has been reached. So the question here would be for lawyers to consider whether or not a settlement was reached if the party didn't sign it. So they may have discussed, yes, I'm happy with this, but you can discuss that you're happy with this, but is there a settlement really, Surinder, if you later on don't sign the agreement? and you say, actually, I'm not happy with this, your lawyers may argue that, yes, there was an agreement because there were other two parties who've agreed to it, and we can rely on that, and we can inform that to the judge when it comes to the issue of costs, not maybe on the issue of whether or not you're successful in your legal argument, but on the issue of cost, there could be cost implications for that person.
Okay. Fine, thank you.
Does that answer your question?
Yes, it's a sort of gray area, but I have been through mediation before. We
Yeah.
agreed everything, but before signing, the other party just reneged and walked away.
Yes. Yeah.
I think obviously, Surinder, you didn't hire Reema, and it's a fascinating.
Dale,
Yes.
did you hear what Reema said? She made it clear that she does not enforce anything. She just tries to bring agreement.
Mediators can't force anything. That's not our job.
No, I
We
meant
can't.
in terms of the mediation. So, you know, you just needed a better mediator. And so thank you for those questions. And Reema, I'd really like to thank you because you just stopped me changing some locks. I was just on. Thank you for that. No.
I'm glad we saved you from the news. That was more important than the England finals.
No, come on, look.
You can help us mediate when we argue who's buying the next round.
Yeah, that'll be on Sunday.
He'll never buys a round. Yeah.
Of course not. I have to get all the 50Bs I have to keep putting in for you guys. Look, Reema, thank you very much.
No problem.
It's been really, really informative. And like I said, it was worth taking time out from the England celebrations, and obviously just stopped me in the nick of time changing the law. Will you please come back on the show and give us one of your other webinars, because from what you've given us today, it's amazing information, that especially on mediation, because you know,
Yeah.
from my line of work, mediation is being promoted, and like you said, if you can get that outcome, it's a much better outcome than going to courts with lawyers, and you being a lawyer saying that should hold double the weight.
Well, absolutely. I mean, there's nothing that you're losing by mediating, because as I mentioned, it's all confidential. If you don't reach an agreement, you've still only spent probably less than a quarter of what you may spend in legal fees if you were to sort of engage the services of a law firm or a solicitor. I'm not cutting my main profession here, but I'm just sort of, my point is to try and spread the awareness that we don't actually have to spend as much money to resolve our conflicts, which are natural by nature. We will end up in situations that we find we never expected to be, and those are legal battles. And as a lawyer, I believe it is my duty to try and let people know that it's not all bad out there. It's actually there are other tools available to help you resolve your legal battles. And if that fails, then of course, people like myself and other litigators are around to fight your battle and take you to court and get your judgment. But of course, if you can resolve it by a cheaper and cost-effective method, then why not?
Why not, indeed? No.
I'll definitely put you in my good books, because you've just sort of gone from the lawyer's bad books. I hope there's not lawyers.
They all say that, and that's why mediation's very busy for me now.
You know, lawyers, we come across them that no comment. I'm not going to go. I'm already enough trouble. But it's great to have you on. Thank you for sharing the mediation.
Thank you for having me.
And please come back and do another session with us. We'd like to
Definitely.
get to understand more about construction staff mediation, especially if you do boundaries. That's my favorite bugbear at the moment.
Oh, lovely.
Yeah, so yeah, I hate that stuff.
That's where I started my property litigation career: boundary and trespass and tree damage and tree root claims. They still exist.
We're going to get you on to do a special program for that. Now you've volunteered yourself, so do that special program. Look, we're running out of 50Ps, but secondly, we've got to carry on with the England celebrations. But more importantly, I think we've taken up all the time you booked for us. So thank you very much.
Thank you, Reema.
Thank you, Ranjan.
Thank you for having me. Thank you, Linda, for your questions.
Okay.
I hope the answers were somewhat helpful, but of course, if you want to discuss further, then do feel free to get in touch.
Can you
So I will. Thank
slide
you.
back on, please? Bob,
Sorry.
Yep.
put Reema's contact details back on because.
Oh yes, let's do that.
Do some work, mate, before you start buying the pints in.
Yeah, I'll try and do that if I can find it. 1 second. I sort of closed it off, I think.
You were getting ready for the celebrations, right? Come on.
I'm not sure if I put them on the slide, Bob. So that's not your fault. But
Yeah.
I'll send you an updated slide for the.
Yeah. Bill's trying to be smart again. That's what it is.
You said the operative word there. So anyway, stuff like that. Talking about smart, Bob. Talking about smart. We've got a guy coming in 2 weeks. He's got more letters than the Russian alphabet behind his name. I'm obviously talking about Arif Panjani. He's there.
Oh yeah, I know. Yeah.
So actually, Reema, I'm not going to embarrass you. I'm not going to ask you how many letters you've got after your name. I'm sure it's more than one. Got put together, right?
Not many.
I think you've got the good ones, the mediation ones, right? So Arif's literally got more letters than the Russian alphabet. It's like huge number of letters. He's here in 2 weeks' time. We've got a special guest next week, so hopefully everybody can join us for next week and the week after. And hopefully next week we've got even more to celebrate. It's coming home. We better disappear. So see you guys, everybody, next week. Great show. Thank you for joining us.
Thank you.
Thanks, everybody. Thank you.
Thank you.